So today I am going to discuss about one of the important Supreme Court ruling. Uh, you can refer the case of Anjani Technoplast Ltd versus Shubh Gautam sir as a critical gatekeeper in this judgment. Supreme Court utilized this judgment and reinforces that NCLT is not a collection agency and that the presence of debt does not automatically justify the destruction of a functional company. So the court disputes, it was basically a creditor sought to initiate the corporate insolvency resolution procedures against a solvent company based on the final money decree, effectively using the NCLT as a execution court. So the test, insolvency test, was very important to be initially carried out. So Supreme Court has carried out and emphasized that if a corporate debtor is a going concern with the financial capacity to pay triggering IBC for a single default is an arbitrary use of the law. So you cannot apply the IBC in case there is a arbitrary use. So key judicial dictum by the Supreme Court is that IBC is intended for the revival of distressed company entities and not for the extortion of dues from the solvent one. So distinction you can see here that differentiate inability to pay insolvency and mere default for recovery. The IBC target the former, civil court handle the latter. So this resolution versus recovery, the matter basically conceptually divide in two different manner, and Supreme Court has amply clear that how does it going to affect. So Supreme Court basically given this very clear verdict in a matter of IBC that IBC is a shield for revival and not a sword for recovery. So with that wording, if I go with, so a ruling in Anjani Technoplast Ltd versus Shubh Gautam has drawn a definitive line in the sand. For too long, the Insolvency and Bankruptcy Code IBC has been treated by some of authorities, some courts, some advocates, some judges as a measures of high pressure collection agency. This judgment reinforces a core truth. The NCLT is for fixing the company, rather to improve the health of the company and bringing the company from the insolvency, say liquid environment, not just for collecting check. So this case has spotlighted and the court sent a clear warning to the creditors attempting to bypass standard civil execution proceedings. If a company is a going concern with the ability to pay using the threat of insolvency to settle a single debt is an abuse of the law. So there is a great divide between the resolution versus recovery. In personam recovery, a one-on-one battle, the goal is to satisfy a specific creditors even if it means stripping the company assets to the bone. And in RAM resolution, the collective effort, the goal is to keep the company alive, maximize its value and protect everyone from employees to the state. So the philosophy which very profoundly known as the Swiss ribbons, this isn't new but it is being more strictly enforced following the Swiss ribbon 2019 the precedents. The court views the section 14 moratorium as a protective cocoon, and it's meant to give a distressed company room to breathe and recognize, not to serve as a weapon to freeze a solvent debtor operations. And here IBC misuse and red flag of IBC, the judiciary has corrected, is now actively looking for this recovery tactics that targeting solvent debtor, pushing for insolvency against a company with a healthy cash flow over a disputed invoice. Course intent using the CIRP proceed to jump the queue and bully a settlement and bypassing civil court using the NCLT because we don't want to wait for a standard civil decree executions. So bottom line in this matter is that IBC is a beneficial legislature aimed at economic revival. By dismissing the petition in a Anjani Technoplast, Supreme Court has protected the spirit of code from being diluted by the individual greeds, if you exactly want to hear the word, and henceforth the Supreme Court has clearly defined the IBC is merely a beneficiary legislature and henceforth should not be treated as a shield for revival and henceforth to be treated as a shield for revival and not a sword for the recovery. I hope you might have got the understanding of this case matter for the IBC, where Supreme Court ruling in the matter of Anjani Technoplast Ltd. Shubh Gautam. If you like my discussion in this matter of IBC, insolvency and recovery matters, where debt recovery suit and CIRP, these are the two way of resolving these matters. So if you like my communication, please share and subscribe and put your comment if you have some other thoughts on this. Thank you.